Hi, I'm Emily, and I am here with Maya Murphy's attorney, H. Daniel Murphy. Attorney Murphy practices at Maya Murphy's law offices in both New York and Connecticut. My question today for Attorney Murphy is, what is supervised visitation and when is it appropriate?
As family law attorneys practicing in this area of law for a long time, as well as in the area of criminal defense and handling child protection matters, we often do see cases in which the safety, health, or well-being of children is sadly put at risk. In a Connecticut divorce or in a custody matter between two unmarried parents, the court is charged with determining what is in the best interest of the minor child at any particular time. And the court will consider a number of factors in deciding what's in the best interest of children. And those factors are particularly important when the child's health and safety are at risk. So the court will look to, for example, the needs and the temperament of a child, the ability of the parents to meet those needs, the preferences of the children and the parents, and also the details of the child's relationship with both parents. The court's also going to look at the parents' willingness to encourage a positive relationship between the child and the other parent, and any coercive behaviors by either parent to involve the child in the dispute, as well as the ability of the child to adjust to a new home environment, a stable home environment, and also the child's cultural background and any factors that might relate to that. But as part of the analysis, the court will also look at the physical and mental health of each parent, as well as the history of each parent's patterns of any abusive behavior within the home or elsewhere, either relating to a child or otherwise. And also the court will look to whether or not the children have been neglected or abused in any fashion. In those types of cases, especially where a parent is involved or has been involved in some serious criminal law proceedings, or where there's evidence of abuse or neglect in connection with that particular child, or for example, with some kind of habitual or serious drug use, or even if there's a treatment protocol in place, those are instances where a court may consider supervised visitation. That is assigning a third party, an individual, to look after a parent's parenting time with a minor child. And if there's, especially if there's a mental health issue of one parent which directly impacts that parent's ability to parent or to engage in meaningful parenting time, that is a situation also where supervised visitation may be appropriate. Now, it could be the case where supervised visitation is ordered after a hearing on parental access. Very rarely is supervised visitation something that's agreed to by all the parties. Sometimes there's supervised parenting time that's ordered in connection with a hearing on a restraining order, where there exists some kind of serious concerns about one parent and the impact that that parent could have going forward with the children or with the minor child, especially where there's evidence that there are prior court orders that were in place that were not followed. A supervisor that's assigned could either be another family member, and this is something that's sometimes done by stipulation. Once a court decides that supervised visitation is appropriate, the parties might determine between themselves who the supervisor should be. So sometimes, like I said, it could be another family member, it could be the other parent, it could be a professional supervisor service of some kind, and these exist. These are individuals who are trained in child development and conflict resolution. It could be a psychologist or a family therapist. And supervision also, you should know, is not ordinarily open-ended. It doesn't go on, ad infinitum. It's typically there's some kind of benchmark that's set up, whether it's a time parameter of some kind, or maybe the opinion of a third party, such as a therapist or a psychologist, who would at some point decide that supervised visitation is no longer necessary. Child custody orders are always modifiable, so if supervision is required or appropriate or ordered by a court now, it doesn't mean that those restrictions are going to stay in place permanently. Often we do field questions from individuals challenging the underlying set of facts that led to a supervision order, or where one parent has genuine concerns about the safety of the children with the other parent. So because supervision of parenting time is an extraordinary and exceptional legal restriction, infringing upon all kinds of constitutional rights, no matter what side of the equation you are on, it is very important to consult with a family law professional about your rights, your obligations, and your legal protections with these types of matters.
Attorney Murphy is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney Murphy at hdmurphy@mayalaw.com, and please visit mayalaw.com for more information.